petitioner, because the High Court says, below the stand is that this has to be exchanged between the petitioner and the respondent. So UGC is under obligation to forward the copy of the affidavit on my client or on the advocate of record that has been given. And whatever may be the circumstances, my lord, Mr. Samanto and Mr. Bandyopadhyay, Ganguly, my lord, learned senior advocate, they have, my lord, categorically stated that it is the government has taken a stand that from 2016 to 2019, we did not pay, we could not pay, and we are not obliged to pay. My lord, when it is a question of obligation, my lord, there is no question of performance of any duty. That is the stand.
Yes, yes.
Duty emanates from, my lord, the
not
concept of obligation. If
No,
that is
this
Not debating the stand
not
right now.
debating.
they said that they look into no, they look into it because this is a
Yes.
ramification. According to them, if I ignore this, whatever may be the stand taken by the UGC, even if UGC supports Millard, then Millard, I tell your lordship, my kindly pardon, Millard, I normally, Millard, take adjournment in many matters. It is not that, Millard, this is a solitary instance. Question is, Millard, that one must be consistent with one's conduct.
Yes.
Today, my lord, this is not mutually, my lord, it cannot be reconciled.
No, what is your objection?
My objection is that let him complete today.
Yes, he is.
No, he said, my lord, unless and until he looks into it, he cannot. Yesterday night, my lord, when the conference was held, my lord, he suddenly discovered and he was taken by surprise that UGC has taken this stand. This is not correct.
UGC has not taken stand today.
UGC has already taken its stand. Yes. So this was 2 years ago. So
No,
this was
9th of
not.
April,
So these are all right. April. I take it. But today, my lord, he cannot say that this is not. He cannot, my lord,
Sorry,
act
just-
like an Alice in
But
Wonderland.
yesterday I learned from
let
Mr.
me
Basu.
hear.
Today I also learned.
I am not his teacher, my
No,
lord.
no, no. I have also learned. I have just uttered a word that on 9th of April, your lordships recorded an order that UGC filed the written notes of argument. During conference, it has revealed that we are required to look into it, and only for this reason he submitted for so long. But perhaps this was not required. But my only stand is this, my lord, we have completed on the ground regarding the fact and the proposition of law. Only the two judgments we are required to we are supposed to submit before lordship, and the proposition of law from the Holsbury. Mr. Ganguly has categorically stated. Now, my lord, only the thing, my lord, may I humbly request your lordship to get the written notes of argument from the UGC, and may we reply on that, my lord, also on a next day,
No, whatever may be UGC said, whatever may be the central government say, you are not bound by that.
we are not
It is-
bound, my lord. What
it is your
are their stand, my lord? We are required to look into that, my lord. Only that much,
Why
my
you
lord.
not look into on the other before starting argument?
No, my lord, we have not. On 9th, yesterday night we looked that, my lord, on 9th of April, your lordship passed an order that they have submitted written notes
Yes,
of
they have
argument.
submitted it.
Yes,
also,
my lord, we
but
have not.
on that date you must have asked
No,
for a
we were
copy
not
of
there,
that.
my lord. We are not there. On 16th of April, we were there. 9th of April, nobody kindly look into the order sheet recorded by lordship. Nobody was appeared.
9th April order was discovered yesterday night. All right.
Yes.
Sometimes it happens.
Yes.
But the question is, my lord, that they said they were absent from the court, my lord, for which neither court nor the petitioner
No,
is
it is
responsible.
my fault. On and
They,
from,
my lord,
we are
then, my
not
lord,
there.
my lord, your lordship is facing, my
But
lord.
today what you want?
Want adjournment? Simple.
If it is a drama class, I can understand. Mr. Bose can argue very well, showing it's a drama class.
No,
It's
no,
not a drama
no,
class.
no, Mr.
I can
Samanto,
complete
just
the
wait.
argument.
Just wait. So
It's
when
not that I not started.
No, let him start. He
I
has
have already
he has-
started.
no,
If you do not understand,
this is the third day, my lord. Kindly see how many adjournments have been taken.
when I entered appearance, I started, and thereafter it took 2 days. And not that they
Let him conclude.
that
We are
it is not
suffering.
the fact that we took adjournment on last 2 days.
Government is not paying our legitimate dues. Forget about the DAs.
You are not after all entitled to.
very well. So tomorrow,
Lord, any day next week, Lord. Any day next week. Any day next week.
Kindly record, my lord, that his
Yes, yes.
Monday 12:30.
my lord, 18th I cannot Milord, 18th, Milord.
16. 30. We have 30. We have 30.
Milord, nothing, Milord.
না জোসেফ বলেনি কিছু।
16. You have 30 ফাঁকা আছে। 17. We have 30. 17, 12, 30.
17, 12, 30.
17.
Milord, let them conclude
Sometime
on Milord,
at 12,
17th,
calculate 12.
17th, Milord, not 2 p.m., 18th, 2 p.m. not possible.
I have fixed several matters.
Milord,
17th, 18th.
Yes.
if you suits your lordship, you
Yes,
can fix at 12.
but
Milord.
Milord, kindly record that he should conclude and Milord, then Milord,
12,
17th,
30 is
Milord,
there
we
are
will be on virtual mode.
5 minutes. They can conclude.
Yes.
Milord, may I get a copy of from the UGC? Milord?
You ask for UGC from that, not from the court. Okay.
And Milord, then Milord, kindly give us a chance, Milord, to confront him, Milord. Next day, because I
Yes.
will not, I will,
You
he will
have
be
the
not.
chance to reply.
Yes, yes.
You have the chance to reply. Their argument, thereafter UGC shall argue, and thereafter you reply.
Then,
At 12:30, 17.
12:30.
Milord,
Please take down. An accommodation is sought for on behalf of the state respondent. Strongly objected to by the petitioners. That the matter appear in the list on 17th of June 2025 at 12:30 as a specially fixed matter for argument on behalf of the state respondent.
Milord, adjournment sought on ground that we require the. Milord, kindly note that, Milord.
No, that is not the ground.
As your lordship.
Mr. Basu had addressed. Thereafter, my lord, part.
Mr. Chaturvedi is arguing.
Yes, Mr. Chaturvedi is again going to address.
Milord, I'm sorry, Milord, for the inconvenience caused to my learned senior friend.
We are always here to accommodate Mr. Basu.
Milord, in our stream,
Yes.
Milord, recapitulations, they act as kinetic energy. Milord, we need to recapitulate, Milord, to gain the momentum as to where do we start from.
Yes.
Milord, briefly, Milord, I ended, Milord, placing as to what is the scope of this application. And when I said that what is the scope of this application, Milord, I also placed before my lord as to what are the respective stands taken by the plaintiff and the defendant before the trial court. And why, while admitting the second appeal, this honorable court was pleased to impose a condition of granting only the contractual rent,
Admitted contractual.
admitted contractual rent, and not rent at market value. And my lord, I also, my lord, submitted that Order 41, Rule 5, my lord, to be exercised by a court of appeal granting a stay and imposing a condition thereof. Lord, it in a way is an ancillary order to the extent that it attains finality and it is not related to the main merits of the case. A revisit to it is sought for on the ground that the quantum should be increased. And such an application is being moved, I would say, before a coordinate bench in the garb of an application for recall or modify. My lord, I submitted before my lord as to what are the conditions postulated to recall an order.
Yes.
When is an order liable to be modified? My lord, I submitted before my lord that there was a conscious adjudication of rights in the interregnum till disposal of the appeal, when this appeal was admitted and substantial question of law was framed. The Honorable Division Bench desired that till the appeal is heard, my possession would remain protected subject to fulfillment of obligation as would be imposed by the division bench. So there was a conscious adjudication. But the application was finally disposed of thereafter. In 2010. And the orders were passed on contest. But it would not emanate from the orders, both the orders, that any stand was taken that instead of benefiting the landlord with only the admitted contractual rent, a different or a higher obligation should be imposed on the tenant and corresponding better benefit be bequeathed upon the landlord even in while the appeal is pending. Means dispense with the condition of admitted contractual rent and replace it by market rent or the rent at which the property would fetch if it is let out on today. That was not the stand taken. I say, what are the altered circumstances which today would persuade this honorable court to revisit the issue, except for the fact, if I may use the word with deepest of restraint, I would say, apart from the greed of the landlord. And if it is so, then that cannot be a reason for the court to revisit, especially when an application is for recall. But the scope of recall, my lord, I would cite judgment, but my lord knows, my lord, it is trite law, is confined to an order which has been passed without hearing the other side.
In the absence of other.
In the absence, or even if, my lord, a plea is taken that though I was present, but I was not heard. I was not heard. And this is how I am being prejudiced. A modification is only to a little extent of altering the order apropos any arithmetical calculation, apropos any minor alteration which may have erroneously crept into the order. and such an error is adversely affecting a party, can come up in modification. This is that small modification that I am seeking before my lord. But this application, although Lord, it would seem very innocent that I am just seeking a recall of an order. I am seeking that the rent should be increased. But in effect, what is being sought for is kindly replace the word admitted contractual rent with that of market value. And the Honorable Division Bench, while admitting the appeal, had the option of granting this relief, but consciously did not grant it. So today, this application seeks that my lord should sit in appeal over the judgment passed by this honorable court in admitting the appeal and in passing the order, casting obligations and determining the rights of the respective parties till disposal of the appeal. Lord, these interim orders, Lord, are in a way final in nature, appointment of receiver, injunctions to remain till the disposal of the suit, although they do not touch upon the merit of the case. Identically, Order 41 Rule 5, imposition of a condition to protect the right of a judgment debtor subject to fulfillment of the condition imposed,
Yes.
and is to operate till the disposal of the appeal. Now, my lord, on the last occasion, my lord, I fail to recollect, my lord, as to whether I, my lord, showed my lord the relevant paragraph of my written statement as to what is my stand and why this honorable court in admitting the appeal was persuaded not to grant market rent. Lord, kindly, Lord, permit me, Lord, to trouble your lordship with just, Lord, a few lines from the written statement to only demonstrate that this was the reason why this honorable division bench did so. Lord, my lord has the written statement with my lord.
LCR.
Lord, kindly do not, Lord, take the trouble, my lord, of browsing through the LCR, but the written statement is here. Lord, kindly turns to page 3. Lord, kindly sees the first line in the premises. My lord has very kindly got it. In the premises, the defendant number 1 states that there is no relationship of landlord and tenant between the plaintiff and the defendant number 1. The defendant number 1 further states that at all material times, the defendant number 1 has been and still now is a tenant under the defendant number 2. The landlord of the said premises. The defendant number 1 further states that the sum of rupees 454 being the rent of the said office room is inclusive of proportionate share of the multi-storied building tax. And then, Lord, the next paragraph, kindly skip over, Lord, the first 3 lines. Lord, the 4th line starting with the words, the defendant number 1 has been. The defendant number 1 has been in use and occupation of the said room number 8 as a monthly tenant according to English calendar month since the month of February 1923 under so and so Bangar until the said premises was transferred by the same firm in favor of defendant number 2. So, my lord, it was transferred in favor of defendant number 2. I became a tenant under defendant number 2. My specific case is that the defendant number 1 is only, my lord, entitled to collect the rent. Apropos the defendant number 1, I have denied that there exists any landlord-tenant relationship. To such a person, the court said you need not pay rent at market value, because if you are denying the relationship, then you may not be liable to pay at market value to this person. This occupational charge.
This is a written statement, whether this written statement considered at the time of passing the order by the division bench.
But I say this is my submission is that the court considered the respective arguments. The trial court considered the respective arguments and passed a decree against me.
Yes.
Before the division bench, the respective case was considered.
So your submission is that the case of the defendant was considered by the division bench, and the division bench has passed the order consciously regarding the contractual.
Yes, I shall show what issue is framed. My lord, from that, my lord's query would get answered. And then, my lord, kindly sees paragraph 3. This is the last, my lord, of the written statement that is relevant for me to indicate. In or about May 1979, plaintiff represented to the defendant number 1 that the defendant number 2 had executed a lease of said premises in favor of plaintiff, subject to tenancies of the existing tenants of the said premises, with authority to collect rent from the said tenants. The plaintiff further requested the defendant number 1 to pay rent to the said room to the plaintiff. Relying upon the aforesaid representation of the plaintiff, the defendant number 1 had paid the rent to the plaintiff as lessee, having authority to collect the rent. Now kindly see, my lord, while admitting the appeal, kindly sees takes up the stay application. Admission at order. Kindly case me. Ground number 3. Ground number 3. Ground number 3. 64. Ground number 3. Lord, the appeal was admitted. My lord would see the first line of the order at page 63. The appeal is admitted for hearing on ground number 3. The kindly sees ground number 3. May I read, my lord? Whether the learned judge erred in law by not holding. Lord, I hand up my copy to my lord, my lord.
I have the copy.
Whether the learned judge erred in law by not holding that the appellant was a tenant directly under the original owner, and the lessees were the lease was granted to the plaintiff when the appellant was already occupying the suit premises as a tenant alone. That I am a tenant under the original owner, whether this fact was not considered by that court. This ground 3 is in consonance with my pleadings in the written statement, which I placed before my lord in paragraph 2 and 3 of my written statement.
Yes.
Now, my lord, kindly, my lord, takes up the application. Lord, kindly sees paragraph 3.
Can 930.
My lord.
Can 930. Can 930. Puruno can. Old can. Yes.
Lord, kindly sees Lord paragraph 3 on internal page 3 of the application. My understanding of this case and my understanding of the ground on which the appeal is admitted is also understood in like manner by the plaintiff respondent. Kindly sees the appellant entered appearance in the suit and filed a written statement. In the written statement, appellant alleges that the applicant plaintiff is not the landlord.
This is the application for stay of operation.
No, no, no.
Can 9. Can 9.
My lord is hearing can 9.
Yes. Paragraph 3.
Yes,
Yes.
my lord. My lord, kindly sees paragraph 3 would be at internal page 3. The appellant entered appearance in the suit and filed written statement. In the written statement, the appellant alleges that the appellant plaintiff is not the landlord. So this is, my lord, the understanding of the respective parties as regard the respective case, my lord, is in consonance. Is in consonance. And this is a moot issue which has been framed as a substantial question of law, my lord, under section 100 by the Honorable Division Bench.
Yes.
Now, my lord, kindly sees my lord, paragraph 8 in connection with the said appeal filed by the appellant. An application being Can 930 of 2005 was filed praying for stay of all further proceeding of the execution case pending before the learned Small Causes Court, 4th Bench, Calcutta. After hearing the parties, this Honorable Court by an order dated 6th April 2025 disposed of Can 930 of 2005 by ordering the following. Lord, I take my lord directly to page 63. Which is this order.
Yes.
But the last 4 lines starting with the words accordingly. My lord has very kindly got it. Page 63, last 4 lines. Accordingly, we grant stay of all further proceedings of execution case number so and so pending before the so and so for a period of 6 months from date or till the disposal of the appeal, whichever is earlier, with the liberty to apply for extension in the event the appeal is not disposed of within the aforesaid period time on the following conditions. The defendant appellant will deposit arrear of rent if there be any and all decretal cost within a period of 4 weeks from with the executing court. The defendant appellant will go on paying occupational charges at the rate of monthly rental, at which it was lastly paid from the month of April 2006, which will be deposited by 2005, deposited by 15th of May 2005, and thereafter for every month by the 15th of each succeeding month. Now, my lord kindly sees, Lord, page 63 once again. This is, my lord, an order on contest.
Yes.
But there is nothing to indicate that there is a submission to the effect that instead of monthly rent, it should be occupational charges at a rate which the market value for the said property would fetch if it is let out. This order was accepted. There is no, my lord, appeal against this order. Then, my lord, kindly comes to paragraph 9. Subsequently, the appellant had filed an application before this honorable court, being Can 1133 of 2007, wherein by an order dated 8 September 2010, the interim order was reimposed and extended till the disposal of appeal or until further order, whichever is early. When an order is extended or reimposed, the opposite party has another opportunity to seek for fresh conditions be imposed as a condition precedent to extension or reimposition. So this position was accepted in 2005. Acceptance was reiterated in 2010. There is no challenge to this order as well.
Yes.
Lord, kindly comes to page 6, paragraph 13. As such, the monthly letting out value on a conservative estimate would be 1,48,200. This is the cause. This is the cause which, my lord, with due exercise of restraint, I define it to be a greed. And this greed cannot be a cause to seek recall of an order, because the order passed was on contest on both occasions. An aggrieved party had only remedy before a superior forum. If the landlord was not satisfied with regard to the condition imposed under Order 41 Rule 5, then his remedy lay by preferring an appeal before a superior forum, that is the Supreme Court. And then, my lord, kindly comes to, I'm sorry.
Yes.
Kindly come to paragraph 16 on the next page. The order dated 6th April 2005, passed in Can 930 of 2005, be modified or varied, and the appellant tenant occupying the suit premises be directed to make a payment of occupational charges 1,48,200. There is no other justification. Now, justification is sought to be given to the quantum of 1,48,200. How do they arrive at this figure of 1,48,000? I am at the moment on the preliminary point of whether this application can be maintained. Now, admitting not, assuming not admitting that this application can be maintained, kindly see, to justify this quantum, what material has been produced before my lord. Lord, kindly comes to page 66. Lord, this is, my lord, a leave and license agreement. My lord knows, my lord, that there cannot be, my lord, any rateable comparison between the license fee and rent under the statutory law.
Yes.
Lord, kindly sees page 67. Lord, this is, I refer to paragraph 4, covenant 4, that the center shall provide 1 executive table, 1 executive chair, and 5 visitor chair in executive type cabin. Adequate lighting and air conditioning shall be provided in the unit These shall be provided as standard furniture and fixtures, and no separate charges shall be levied against them. There are charges for each internet usage, so and so per month. So this is, my lord knows, my lord, the modern concept of workstations. Lord, I came to learn only the other day from my children. I did not know that there is a concept called workstation. They say that it is a small cabin with a table, chair granted, cubicle, a cubicle. Cubicle is the right word. Internet facility is given, the AC is full blown, and one is given a small bottle of water and a coffee. Now, this is, my lord, a modern facility granted. It's I say, the service charges, the utility charges, all combined into one, and a lump sum amount is being charged. Neither the status of the licensee here and the appellant, who is a tenant, is comparable, nor the facilities are comparable. Because as a tenant, I don't get any other facilities even except what are provided for in the statute, not the rights of a tenant. Okay. So, my lord, this is, my lord, of, my lord, no consequence. This cannot be, my lord, treated to be any parameter. Now, the next agreement, which is, my lord, produced before my lord, is at page 71. This is a lease agreement. My lord, kindly comes to page 73. Kindly sees covenant 2.1. The lease shall be for a period of 9 years from the date of commencement. Now, my lord knows, my lord, these short-term leases, my lord, again, akin to the license agreement, my lord, the scales of rent fixed, my lord, are disproportionate to that, my lord, under that of a statutory tenant, to that of a statutory tenant. Because, my lord, these are, my lord, for short tenures.
Yes.
These are for short tenures, and they come with facilities. There is, my lord, nothing else to arrive at the magical figure of this property likely to fetch 1,48,200. Showing these agreements, what is being shown is that the market value is rupees 100 per square feet. I say neither the property and the facilities are comparable, nor the status of the licensee and that of the appellant are comparable. So these cannot, blood, act as, blood, good parameters for determination of the quantum as proposed by the applicant.
Yes.
Blood, I need to show that I have said these things in my affidavit in opposition to the application. Lord, kindly takes up my affidavit in opposition to Can 9. Affidavit in opposition. Can 9, affidavit in opposition. নতুন হবে। Lord, kindly comes to paragraph 3. Lord, kindly sees 3D. I'm sorry. Internal page 4. 3D. I say that the present application is not maintainable, as the sole ground which has been assailed as a reason for filing the present application is bereft of any reason, as it has been stated that a purported subsequent judgment has been passed wherein it has been directed to make payment of monthly rent at a market value. But the judgment, my lord, has been cited by Lanfra. I shall deal with that. But I say the application is not maintainable. Then Lord kindly comes to H on page 5.
Yes.
The plaintiff respondent did not prefer any appeal against the said order, which was passed on 6 April 2005 within the statutory period, and as such, in the guise of recalling modification of the said, the plaintiff respondent filed this application, which is otherwise an appeal against the order dated 6 April 2005. Then I, the plaintiff respondent, accepting and admitting the order dated 6 April 2005, preferred no appeal, and such the order has attained its finality. Therefore, this application is not maintainable. Then Lord J, I say if an order is sought to be recalled, there should be definite grounds and reasons which are being provided under law wherein an order can be recalled. I say that an order can be recalled on these few grounds: if an order has been passed without serving a party, if an order has been passed ex parte in the absence of a aggrieved party, if an order has been passed by a court having no jurisdiction to pass an order. Then N, I say that the basic ground for filing the present application is that the judgment has been allegedly passed by a court wherein it has been allegedly being held that occupational charges should be paid at the current market value. Then Q, the application can 9 is wholly misconceived and the claim is barred by limitation. But kindly Lord sees that this is an application where the enhancement is sought for with retrospective effect. With retrospective effect. Assuming that this constitutes a money claim, it's again, my lord, the duty of the court in terms of section 3 of the Limitation Act. I may not raise a point, but my lord would see as to whether the claim is barred by limitation or not.
Yes.
Lord, the judgments cited by my learned friend, even those judgments, my lord, where the enhancement has been granted, I shall show as to in what type of proceeding the enhancement was granted. The enhancement has been from the date of application. And these were no original proceedings under Order 41 Rule 5, but an order is passed under Order 41 Rule 5, which is challenged before a superior forum, and then the court has said, no, this fixation of occupational charges akin to the monthly contractual rent is not proper. This should be enhanced.
Yes.
I again say, with deepest of respect, that such a remedy was open to the applicant in challenging the order dated 6th April 2005 or even the order of September 2010. Huh? September 2010. But they accepted not this position of casting of obligations and determination of rights till the disposal of the appeal, both in 2005 and in 2010. But today, greed cannot make them wiser. Law does not give them any right to seek revisiting that order in the garb of the present application. So, my lord, I have dealt with section 3, my lord.
Yes.
Insofar as the claim with retrospective effect. But my primary point remains that the application cannot be entertained. They do not have a right to seek a recall. But assuming not admitting, then the parameters are no comparable parameters. 2, that the sprayer of grant since the date of filing of application again would be hit by limitation. And there, my lord, I rely on section 3 that it would be the duty of the court to look into the claim as to whether it is barred by limitation or not. Lord, usually, my lord, we side distinguish the judgments. My lord, in this case, kindly permit me, my lord, to digress, because the judgments cited, my lord, are so persuading that I first need to distinguish them before, my lord, I proceed on my lord, to rely on my own judgment.
Yes.
My lord, kindly takes up, my lord, 2022 volume 8 Supreme Court cases, page 527. Now, my lord, this is, my lord has very kindly got it, my lord.
2000
This 22, my lord, this would be Martin and Harris.
Martin and Harris.
Now, this, my lord, the proceeding before the Honorable Supreme Court, it related to a determination of right under Order 41, Rule 5, against which, my lord, the matter went to the Honorable Supreme Court. I again say that Order 41, Rule 5, it confers the right on the appellate court to impose any condition that it deems fit. But once it deems fit that it would impose this condition, and it has done so, that the condition imposed is lenient or that it is not commensurate with the securing of decree can be, my lord, raised only before a superior. Lord, kindly sees this. Lord, Lord, kindly come to paragraph 5 first. Lord, kindly skip over the first 4 lines. The 5th line starting on the right hand side with the words, earlier a suit. My lord has very kindly got it, my lord.
Yes.
Paragraph 5, 5th line starting on the right hand side with the words, earlier a suit under section 6 of the old act was filed by the respondent plaintiff against the appellant bearing number 61 of 2002 for determination of standard rent. During the pendency of the suit, an application under section 7 of the old act was filed for fixing provisional rent, which was decided with a order number so and so, fixing provisional rent at 1 lakh per month. The said order was challenged, which was confirmed by the High Court with a order number so and so. The appellant had filed a special leave petition wherein this court fixed the ad hoc provisional rent at 60,000 per month with a direction to the trial court to decide the issue of standard rent expeditiously. The trial court, with a judgment dated 12/8/2009, decreed the said suit and fixed the standard rent at 45,000 per month. The appeals filed by both the parties against the said order are pending before the High Court.
Yes.
So, my lord, the fixation
Itself on the challenge.
right. And Lord, kindly sees paragraph 3 now. On filing an application under Order 41, Rule 5, read with Section 151 of the CPC by the respondent plaintiff asking for mean profits due to continuation of stay on eviction decree, it was decided with the order number so and so, whereby the appellants were directed to pay mean profits at so and so per month from the date of filing of the application till disposal of the appeal. Now, what kindly comes to paragraph 17. Lord, Atmaram Properties, my lord, is relied. In Atmaram Properties, this court held that the appellate court does have jurisdiction to put reasonable terms and conditions as would, in its opinion, be reasonable to compensate the decree holder for loss occasioned by delay in execution of decree while granting the stay. Lord, I lay emphasis with deepest of respect to the words while granting the stay. So the condition, my lord, whatsoever are to be imposed while granting the stay. If I am not satisfied with the condition imposed, if not I as a tenant say that this condition imposed is onerous, but I have a remedy higher up. If the landlord thinks that the conditions are too lenient, too liberal. The remedy is higher up. Then, paragraph 18. After passing of decree of eviction, tenancy terminates, and from the date of landlord is entitled mean profit compensation, depriving him from the use of premises. The view taken in Atmaram has been reaffirmed in Supermax by a 3 judges bench. So, this is the good law, which still is a guiding factor insofar as the principles governing the field of imposition of condition under Order 41 Rule 5 while granting stay is concerned. So, in a way, I would say that this supports me. Kindly now takes up Sumer Corporation 2022 Live Law SC 936. এটা তোমাদের সাইটেশন বাবা, হ্যাঁ बताओ ना। But kindly excuse me, this kindly now, so I shall not come to this when I cite my judgments. Kindly take up Vijay Kumar, Manish Kumar HUF, which is 2024 volume 8.
Yes.
Kindly sees paragraph 23. Again, Atmaram properties has been relied upon, and paragraph 9 of Atmaram is quoted, so I am not citing Atmaram separately, I am relying from here. The respondent has referred to Atmaram properties to submit that landlord's claim for mean profit is not maintainable. Given that no decree of ejectment stands passed against the civil court, we may refer to observations made in the judgment, so and so. Now, kindly sees paragraph 9, and there kindly skips over the first 6 lines. Rather, the 6th line starting on the right hand side with the words depending on the facts. My lord has very kindly got it.
Yes.
Depending on the facts and circumstances of a case, an appellate court, while passing an order of stay, may put the parties on such terms the enforcement whereof would satisfy the demand of justice of the party found successful at the end of the appeal. So, my lord, who can impose and when can it be imposed? Lord, is lucidly clear in Atmaram properties, and as my lord I submitted, Lord, Atmaram properties has been holding the field and has been relied upon with approval even until 2024. This is 2024, Vijay Kumar.
Yes.
Kindly sees the last 4 lines of the same paragraph. In our opinion, while granting an order of stay under Order 41 Rule 5, the appellate court does have jurisdiction to put the party seeking stay order on such terms as would reasonably compensate the party successful at the end of appeal insofar as those proceedings are concerned. So, who can impose condition and when can it impose conditions, my lord? Lord, kindly takes up now, my lord, 2024 SCC online, Calcutta 1178. This is the Bonia Vanijya.
Yes.
Lord, kindly sees paragraph 1. What is the issue, my lord, formulated? The question which arises for determination in this appeal is whether the court, during the pendency of the suit for eviction of an occupier of a premises and determination of mean profits, can order interim mean profits or occupation charges to be paid to the plaintiff by the defendant. The determination of mean profits during the pendency of the suit. That was the issue. Has got nothing to do with occupational charges. In the instant case, the prayer for mean profits Lord, not determined in terms of explanation 4 to section 11 deemed to have been declined. Lord, no separate proceeding for mean profits initiated. On facts, Milord, this does not, Milord, match. Yet, kindly see, Milord, paragraph 2. The appellant plaintiff sometimes in 2020 filed the suit in the court against respondent defendants for a decree for vacant and peaceful possession of a shop room measuring 98 square feet in the west corner of so-and-so. In addition to this, they claim mean profits of so-and-so, of which so-and-so amount was a principal amount at the rate of so-and-so as interest at the rate of 18% per annum. Lord, kindly skip over next paragraph. Appellant plaintiff took out application for an order inter alia asking the respondent to secure the sum of rupees so-and-so claimed as mean profits in the suit. By this judgment, an order dated 14th March 2023, a learned single judge of this court was pleased to dismiss the said application, hence the appeal. So these were the facts. And the issue is in question number 1, during the pendency of a suit, whether mean profits can be granted. Lord, kindly come to paragraph 40. Paragraph 40, 40. And before that, one line, paragraph 39. Application of the principles would depend on the facts and circumstances of, I'm sorry. Yes. Paragraph 39. Application of the principles would depend on the facts and circumstances of each case, where the right of the defendant to possession is in dispute, and such a dispute is prima facie held to be bona fide and substantial, or the defendant has made out an arguable case to protect his possession, then an order for payment of rent or occupation charges over and above the contractual rent cannot be made till the trial of the suit is concluded, finally determining the dispute. Although, again, occupational charges and mean profits, rightly indicated by my lord on the last occasion, are not comparable. But since this has been relied upon, I say, even for mean profits, the court said that if I have a substantial and bona fide right to protect my possession, then in the interregnum, there cannot be anything. If appeal is understood to be a continuation of the suit, and if this principle is applied, but I put this question to myself, but can I be put to any onerous condition to protect my possession? This judgment it does not apply, and to the extent that it applies in my favor. Now, I proceed to cite some decisions. I cite 2022 Live Law Supreme Court, page 936. I think extra copy থাকলে আগে দশ টাকা দাও দেখ থাকলে আমি দিচ্ছি Live Law SC 936. What kindly sees Sumir Corporation. MER. What kindly sees paragraph 1. Feeling aggrieved and dissatisfied with the impugned order passed by the High Court of Judicature at Bombay dated 5th November 2020 in civil revision application number 357 of 2017, by which while admitting the revision application preferred by the contesting respondents herein, original revision is against the judgment and decree passed by the appellate bench of the court so and so, and while staying the judgment and decree passed by the appellate bench, the High Court has directed the respondent original revisionist to deposit so and so per month towards compensation mean profits. So, my lord kindly sees, when was this imposed and who imposed? At the time of grant of stay, and it is being imposed, my lord, by the court staying the decree. My lord kindly sees, my lord, now paragraph 7.2.
Yes.
My lord kindly sees, my lord, Atmaram and Supermax, my lord, both, my lord, have been relied upon. Supermax is a 3 judges bench judgment, if I am not wrong, my lord. And kindly sees, my lord, the fifth line, starting with the words, therefore, in a revision stroke appeal preferred by the tenant who has suffered an eviction decree, the appellate revisional court, while staying the eviction decree, can direct the tenant to pay compensation for use and occupation of tenancy premises upon contractual rate of rent, and such compensation for use and occupation of the premises would be at the same rate at which the landlord would have been able to let out premises and rent if the tenant would have vacated the premises. In the present case, High Court has not done that exercise and determined the compensation market value at which the original respondent acquired the rights of the true property, so and so. So, in this case, the court, my lord, in appeal held that a more lenient and comfortable to the tenant, such, my lord, condition has been imposed, but the Supreme Court, my lord, enhanced it. But the determination again, my lord, has to be done by a court exercising power under Order 41, Rule 5. Well, the next judgment that I cite, my lord, is the 2015 SCC Online Calcutta 2094. Ranjan. My lord, kindly, my lord, permit me, my lord, to remind myself that I made a submission before my lord. That's this determination in 2005 or 2010. It determines the rights and obligations of the respective parties till the appeal is pending. So, in the interregnum, what are the obligations that are cast upon the tenant? What is he bound by? And to what extent the landlord is to be benefited? So, the rights of the landlord to get an amount in lieu of not disturbing my possession is his right, and my obligation is to pay that amount to protect my possession. This is to remain operative till the disposal of the appeal in terms of the second order, which is passed in September 2010. I say that these orders, my lord, are of nature which attain finality in the proceeding and are to operate, my lord, as res judicata at all subsequent stages of the self-same proceeding.
Yes.
Lord, I made this submission.
Yes.
Yes. Lord, kindly sees, my lord, this issue, my lord.
Yes.
Lord, this issue, my lord, has also been incidentally dealt with in this judgment. Lord, the petitioner obtained the decree of eviction of a monthly tenant and is still litigating at the first appellate stage. In the first appeal filed before the appellate court, an order of stay was passed as far back as on May so and so, directing the tenant opposite party to go on depositing the amount equivalent to the rent after a gap of nearly 4 years from the said order, an application is taken out by the petitioner in 2014, taking aid of the decision of Atmaram Properties. In the subsequent application, the petitioner prayed for a direction upon the appellate opposite party to pay occupational charges at current market rate. The application is contested by the before the appellate court, and both the parties have relied upon certain documents. Then the appellate court, after taking into consideration all the aspects, directed the appellant opposite party to pay the monthly occupational charges of 8,000 rupees from the date of application. The petitioner challenges the said order on two folds. Firstly, the current occupational charges should have been directed to be paid from the date of decree, as a definition assigned to the tenant under Rent Act excludes a person who suffered the decree, and this is not relevant. Then, in support of aforesaid contention, reliance is heavily placed on Atmaram Properties that the court, while passing an order of stay of execution of proceeding during the pendency of appeal, should strike a balance between the rights of parties by directing tenant to pay the current market rent as a condition for stay. There is no quarrel to the proposition laid down in the aforesaid judgment, though the subsequent judgment rendered by Supreme Court in State of Maharashtra versus Supermax Private Limited 2009 Supreme Court affirmed and reiterated the ratio laid down in Atmaram, but added a rider that while determining the quantum of occupational charges, the court must bear in mind that those are not excessive, fanciful, and punitive in nature. Then, the contention of the petitioner would have been accepted if the application for stay taken out by the appellant before the Court of Appeal below is resisted at such stage, and the court, while granting the order of stay, is obliged to put conditions directing the appellant tenant to pay the monthly occupational charges at the current market rent value. The petitioner allowed the application for stay to be disposed of on May 21, 2010 and waited nearly 4 years. In this case, over 20 years. The petitioner allowed the application for stay to be disposed of on 21st July 2010 and waited nearly 4 years when the instant application is taken out on July 24, 2014. Then, kindly skip over. Kindly start from the paragraph. So far as the other point, my lord has very kindly got it. So far as the other point that the appellate court ought to have directed deposit of the occupational charges as current market value from the date of decree and not from the date of application filed by the respondent petitioner is concerned, this court does not find any substance in the submission. So, two things. But first, that from the date of filing of application, this submission is of no substance. And two, that the court granting stay has the power, it can exercise while granting stay to put the judgment debtor to such conditions as it may deem fit.
Yes.
But after 4 long years, after permitting the application under Order 41, Rule 5 to be disposed of, then an application is filed and seeking the refixation with retrospective effect. But the court said this cannot be done. Not kindly sees the next paragraph, last 2 lines. The Court of Appeal below. My lord has very kindly got it, Miller.
Yes.
The Court of Appeal below directed the appellant opposite party to pay the enhanced occupational charges from the date of application. The matter can be viewed from another angle. An interlocutory order attains finality at all stages of the proceedings, unless the said order is carried further to a higher court. A party who suffered an order cannot, in the guise of an application based on the principles laid down in the judgment, invite the court to rewrite a fresh order or revisit the order which has already been passed by the appellate court. Let I pause here for a moment. Lord, this is not the sum and substance of my argument insofar as, Lord, the principles of res judicata being applicable at all successive stages within the self-same proceeding is concerned. But the court again says, Lord, at the risk of repetition, kindly permit me, Lord, to read the last line once again. A party who suffered an order cannot, in the guise of an application based on the principles laid down in the judgment, invite the court to rewrite a fresh order or revisit the order which has already been passed by the appellate court. Today, this can 9 is what, Lord, I put this question to myself. If it does not fall within the, Lord, the the four corners of this statement. But the applicant invites my lord to revisit and to rewrite the judgment. Which judgment? My lord, the one dated 6th April 2005 and the one, my lord, of September 2010. If the amount is directed to be paid from the date of decree, it would tantamount to setting aside the earlier order of the court or reviewing the same. Lord, next, my lord, I cite Lord 1963 SCC online Supreme Court page 43. This is also reported in AIR 1964 Supreme Court 993. Lord, kindly sees Lord paragraph 11. Lord, on res judicata. That the question of fact which arose in the two proceedings was identical would not be in doubt. Of course, they were not in successive suits, so as to make the provisions of section 11 of the Code of Civil Procedure applicable in terms. That scope of the principles of res judicata is not confined to what is contained in section 11, but is more general application is also in dispute, is not in dispute. Again, res judicata could be as much applicable to different stages of the same suit as to the finding on issues in different suit. This is the principle, and this, my lord, again, my lord, has been well founded by our court. In Shotodhan Ghoshal's case, the matter went until the Supreme Court. It is, my lord, quoted below, and it's relied with approval. In this connection, we were referred to what this court said in Shotodhan Ghoshal, where Justice Dasgupta, speaking for the court, expressed himself thus. The principles of res judicata is based on need of giving a finality to judicial decisions. What it says is that once res judicata, it shall not be adjudged again. Primarily, it applies as between past litigations and future litigations. When a matter, whether on a question of fact or on a question of law, has been decided between two parties in one suit or proceeding, and the decision is final either because no appeal was taken to a higher court or because the appeal was dismissed or no appeal lies, neither party will be allowed in a future suit or proceeding between the same parties to converse the matter again. The principles of res judicata applies also as between the two stages in the same litigation, to the extent that a court, whether the trial court or a higher court, having at an earlier stage decided a matter in one way, will not allow the parties to re-agitate the matter again at a subsequent stage of the same proceedings. Then, my lord, Justice Pathak laid stress on this passage as supporting him in two submissions made. He made that an issue of fact of law decided even in an interlocutory proceedings could operate as a res judicata in a later proceeding, but the one of instant nature. That in order to attract the principles of res judicata, the order or decision first rendered and which is pleaded as a res judicata need not be capable of being appealed. Even if it is not appealable, yet in this case an appeal could have been preferred. Now, paragraph 12, my lord, it extends. It says that even if the principles of res judicata may not be applicable on all fours, but if the issue is somewhere decided, even bereft of the principles of res judicata, fairness of procedure of law, it debars the court to revisit the issue. We agree that generally speaking, these propositions are not open to objection. If the court which rendered the first decision was competent to entertain the suit or other proceeding, had therefore competency to decide the issue or the matter, the circumstances that it is a tribunal of exclusive jurisdiction or one from whose decision no appeal would lay, would not by themselves negative the finding of the issue by it being res judicata in later proceeding. Similarly, as stated earlier, though section 11 of the procedure clearly contemplates existence of two suits and findings in the first being res judicata in the later suit, it is well established that the principles underlying it equally applicable to cases of decisions rendered at successive stages of the same suit or proceeding. But where the principles of res judicata is invoked in case of different stages of the proceedings in the same suit, the nature of the proceedings, the scope of inquiry, which the adjectival law provides for the decision being reached, as well as the specific provisions made on the matter touching such decisions, are some of the materials and relevant factors to be considered before the principle is held to be applicable. And it kindly comes to paragraph 14. Lord, illustrations, my lord, are given.
Yes.
It is needless to point out that interlocutory orders are of various kinds. Some, like orders of stay, injunction, or receiver, are designed to preserve the status quo pending the litigation and to ensure that the parties might not be prejudiced by normal delay which the proceedings before the court usually take. They do not, in that sense, decide in any manner the merits of the controversy in the issued suit and do not, of course, put an end to it, even in part. Such orders are certainly capable of being altered, varied by subsequent applications for the same relief, though normally only on a proof of new fact or new situation which subsequently emerge. As they do not impinge upon the legal rights of the parties to litigation, the principles of res judicata does not apply to the findings on which these orders are passed. Though, if applications were made for relief on the same basis after the same has once been disposed of by court, would be justified in rejecting the same as an abuse of process of law. There are other orders which are also interlocutory but would fall in different category. The difference between the ones just now referred to lies in the fact that they are not directed to maintaining the status quo or to preserve the property pending the final adjudication, but are designed to ensure just, smooth, orderly, and expeditious disposal of the suit. So once it is decided, it would not be proper to revisit until unless that issues germane they arise at subsequent stage. But kindly turn over the page. Just fourth line from the top. But what we are concerned. But what we are concerned with is slightly different. And that is whether the same court is finally bound by that order at a later stages so as to preclude it being reconsidered. Even if the rule of res judicata does not apply, it would not follow that on every subsequent day which the suit stands adjourned for further hearing, the petition could be repeated and fresh orders sought on the basis of identical facts. The principle that repeated applications based on the same facts and seeking the same relief might be disallowed by the court does not, however, necessarily rest on the principles of res judicata. So I made this submission that even bereft of the principles of res judicata, whether the court would permit. But today, my lord, in this application, I say, my lord, to what object this is filed. Grant me this rent, and subject to payment of this rent, stay. What was, my lord, decided on 6th April 2005? What was decided in September 2010? This was the issue which was decided. The court decided as to what should I pay to protect my occupation. Lord, next, my lord, I cite 2009 volume 2 Supreme Court cases, page 703. Lord, with regard to the scope of an application for recall, variation, modification, or even review, well-known parameters are laid down, and one situation cannot be intermingled with another. Now, what is true for review is not correct, it may not be true and applicable for an application for recall.
Yes.
For review, there has to be an error apparent on the face of record. For recall, there has to be a manifest injustice because non-service of copy unheard.
Yes.
Kindly see paragraph 6. Kindly sees the second line starting with the words, while in review petition the court. While in review petition, the court considers on merits whether there is an error apparent on the face of record. In a recall petition, the court does not go into the merits, but simply recalls an order which was passed without granting an opportunity to an affected party. But this is not the case here. But the order of admission, I understand, my lord, possibly there was a caveat, and hence, my lord, the respondents had a right of audience, and the order reflects that they have been heard. Even in September 2010, when the application was finally disposed of, they have been heard.
Yes.
So recall, my lord, with deepest of respect, my lord, it cannot be invoked. Variation, my lord, there is no persuading circumstances, my lord, to seek a variation. This application, my lord, I would say, with deepest of respect, my lord, is not maintainable. The claim of the applicant that the enhancement, if any, should be granted with retrospective effect is barred by limitation. And insofar as justification of the quantum is concerned, assuming not admitting that that any enhancement is made, the parameters as provided for by the applicant to be the guiding factors are wholly
Not comparable.
uncomparable. Now, those are my respectful submissions. Okay. I say this application should be dismissed. Okay.
Reply.
Whenever, if your lordship desires, like, we can start now or any other day convenient to your lordship. Well, any day except 1st of July.
No, I want to conclude the hearing within June.
Very well, very, very. We're deeply obliged.
If 1st July is a celebration, kindly keep it on 1st July because we are not invited.
No.
I do not know the cause.
Professional reason.
23rd.
আমাদের এখন প্রবলেম হয়ে গেছে এনসিএল চলে গেছে রাজারহাট টাউন রাজা খুব প্রবলেম হচ্ছে যেদিন ওইখানে যাচ্ছি এখানে আসতে পারছি
25th of June, 2 p.m.
very great.
Please take down. Argument on behalf of the appellant concluded. Let the matter be fixed for hearing on reply by the respondent stroke petitioner on 25th of June 2025 at 2 p.m. as a specially fixed matter. Una.
I'm deeply obliged to my.
Okay,
Enough.
thank you.
Lordship.
5, my lord, I am for the appellant. my lord.
Yes.
My lord, recollect on last occasion when they were making the submission. So that will make our reply.
Obviously,
Now,
that should be, because after completion of my submission, my learner friend will get the opportunity to reply.
Yes.
yes,
You have the right to reply.
Obviously.
Hello, you have the right to reply. Let them finish first. Yes, for the respondent.
Lordship. My lord, last occasions, my lord, I have started my submissions with regard to the matter is concerned. My lord, today I am requesting my younger friend and junior friend. He will assist your lordship. I am hearing, my lord, with leave to your lordship, my lord, let him start.
Lord, a suit for declaration, injunction, and eviction of a licensee from the suit premises. The suit premises being purchased and certain constructions being made by the plaintiff, respondent herein, and a license was granted to the defendant. Lord, the trial court dismissed the suit on 3 grounds. That first is that I could not establish I could not substantiate the plot of land which I had purchased. That is the same land which is appearing at the present LR records and subsequent RS records. That is one way. Second thing, the trial court has further did not accept the contentions of the plaintiff that the defendant was inducted by him as a licensee. For the reason, there's a 2 reasons is that the trial court has disbelieved the plaintiff's case for the reason that a person accompanied the plaintiff while the license was granted to the defendant. And the court had raised questions as to how an independent person who doesn't have any interest over the suit property, either as a licensor or as a licensee, why to follow or why to accompany the plaintiff while the license was to be given, while the license was granted to the defendant. And the second is that no document was executed with regard to the license. And the third, there is no license fee. The court has disbelieved that how could a property in respect of which a license to be granted without any document and without any fee, license fee. And the other point, Your Honor, that the portion means the amount of land. The plaint, it has been stated that 8 decimals of land out of 60 decimals of land, only 8 decimals of land was granted as a license,
Yes.
wherein the record shows otherwise. The RS record shows that the defendant was in possession of 4 annas of the land. That is, it comes to 15 decimals of land. While the plaint case means in the plaint, it has been stated that 8 decimals of land was given. And the defendant appeared, they filed the written statement interiorly alleging that no license was granted to them. They came in forceful possession of the suit property, and since thereafter, they made constructions of houses, they dug their ponds out there, they planted plants, and they are in possession. So they denied the contentions of the plaintiff. After Lordship, the evidence after the trial, that the hearing, the trial court, irrespective of specific finding, that plaintiff from the records, from the available records, the trial court has specifically found that the plaintiff is undoubtedly is the owner of the property and is in possession. And it's not about the possession, it talks about the ownership of the land. Subsequently has rejected the plaint as one of the ground, and it was specifically found, father found that the defendant's case, they failed to prove the case because they allege that they are claiming title in advance. Initially, though, the RS record shows that their father was as a licensee in respect of 4 anna shares, that is 15 decimals of land. But in the subsequent records, land records, that is in the LR records, their name has been recorded in respect of the entirety of the said land. But in the evidence, it is father, Your Honor, that it is specific case as I submitted before, Your Honor, that he stated that his father had taken forceful possession of the suit property in presence of other person, and he named 2 other persons who were adduced as evidence, DW, and they failed. They did not admit to that. They said they were not present at the time when the forceful possession was taken. And subsequently, the PW1, the plaintiff, the respondent, the appellant out here, he also stated, initially he stated a forceful possession of the suit property was taken by his father. Subsequently, he has stated his father entered into the suit property. There is no questions, there is no averments or statements with regard to forceful possession of the suit property. And the specific finding of the court in respect of the case of the defendant is this, that the defendant has failed to prove his case. This is one thing, Your Honor. And the defendant had not preferred any appeal. No cross appeal has been preferred. But since my suit was dismissed, I preferred an appeal, but no cross appeal has been preferred by the defendant. So these findings, at least with regard to, Your Lordship, the forceful possession, adverse possession, that goes. They are not in a position to raise any questions or make any submission before this honorable court with regard to the adverse possession. Now, Your Lordship, to see that the finding of the trial court, first appellate court, while the trial court judgment was reversed, whether there is any infirmity with regard to the finding of the first appellate court. My Lord, the first appellate court, my Lord, kindly, I'll be placing, Your Lordship, the portion, the first portion, when the finding of the trial court, where it specifically speaks of my entitlement over the suit property. My Lord, page 10 of the paper book. the first paragraph, after 3-4 lines. There is no dispute that the plaintiff is the owner of the disputed property by purchase. Your Lordship got it?
Yes.
So this is the finding of the trial court. Now, if this is the finding of the trial court, so subsequently, Your Lordship, the learned trial court has dismissed my suit. So
No,
this,
you read next line, next sentence.
yes, Lordship. There is no dispute that the plaintiff is the owner of the disputed property by purchase. From Exhibit 2, it appears that the plaintiff purchased 1.61 decimals of land of the disputed Khatian, but there is no evidence that he got possessions of the property after purchase. So from all the aforesaid documents and evidence on record, also this court failed to come to a conclusion that the alleged relations of licensor and licensee was actually existed in between the parties. My Lord, with regard to the subsequent portions of land, which speaks of, but there is no evidence that he got possessions of the property after purchase. My Lord, this finding is from out of nowhere, Your Lordship. This is the finding of the trial court, but where from it
This is
is,
the finding of the trial court because Exhibit 2, that is the deed of purchase, was placed before the learned trial court,
yes, Lordship,
not the record. Record was placed in the appellate court.
yes.
Record of RSROR was placed in the appellate court. That is the case here. So the point of law is here whether the learned first appellate court, while reversing the judgment,
Yes, Lordship.
it's correct because the judgment of the learned trial court is well founded. This is the point of law. You just read the point of laws involved in this, the point number 1, page 45,
That's I've looked into it.
under section 100.
Yes, Lordship.
This is the point number 1,
Yes.
substantial question of law.
In fact, in reversing the well-founded judgment
Yes.
passed by the learned trial court, relying upon the evidence adduced by the parties. My Lord, with regard to, my Lord, this on the basis of evidence.
Yes, on the basis of evidence,
Evidence.
learned trial
My lord-
court has observed
Yes.
that one document, that is the deed of purchase, has placed.
Yes, Lordship.
It can be said that plaintiff is the owner of the property, but no record or other evidence was placed before the learned trial court to show that he is in possession or there is any relationship between the plaintiff and defendant as licensor and licensee. This is the
My Lord,
on the basis of the record,
yes,
on the
my
basis
Lord,
of documents.
yes. My Lord, the plaintiff had, it is the plaintiff's case, and he has tried to prove his case before the learned court below, that after purchase, he made constructions and inducted the defendant or defendant's father as a licensee.
Is there any evidence except the plaintiff?
Yes, he specifically stated that a person had accompanied him while the license was granted. That was also the case of the plaintiff. It has been made out in the plaint.
Plaintiff made out a case that the license was granted to the defendant.
Yes,
But the fact shows from the RSR that the father of the defendant was the licensee.
father of the defendant was the licensor. Licensee, yes, because
over the
the-
one 4 anna share of the property.
yes, the quantum, that is the only discrepancies with regard to the quantum. But there is no dispute that the plaintiff had granted license,
To whom?
that defendant was a licensee.
Whom? Defendant or the father of the defendant?
Defendant or father of the defendant.
Yes.
But-
But this is the question which was not decided by the appellate court. Whom the license was given? Whether the defendant or the father of the defendant. If you rely upon the RSR, the father of the defendant is
Yes,
stated to be the
yes,
licensee over the 1/4 share of the property.
yes.
And the plaintiff saying that it is the pleading of the plaintiff that he gave the license to the defendant,
Defendant.
not the
Because-
father.
Yes, Lordship. Lord, the
So how
defendant.
do you connect
Just
those?
a minute. Lord, a license after the date of any of the party, either the licensor or the licensee, the license goes. License goes. So out here, the defendant fathers admittedly died sometimes in the year 1984. So after the death of the father of the defendant cannot say that his father was a licensee. He could have been, but after his death, he's gone. He's finished. Now it could happen. It could happen this: the defendant was father. The plaintiff had extended the license to the defendant after the death of their father.
This is not the pleading.
My lord,
Not the
it is,
pleading.
my lord, it is not required to make any such submissions like that, because after the death of the father, when the defendants are staying there, it is admittedly, your lordship, the plaintiff has allowed him to stay out there as a licensee. And for this, lordship, it is not required to make any submission. It's not required to, because since everything is oral, verbal, and in the village area, your lordship,
Not be old like that. The case has to be clear. Pleadings has to be specific.
it is specific. The defendant was granted license. My lord, they can't say that.
Defendant always said
My
that
lord.
my father was the licensee. My
But
father
after
was
the
in
yes,
adverse position,
after
and I am
that is there.
possessing from my father.
But after the death of the father, their father can't.
Whether you have pleaded like that, whether plaintiff has pleaded like that, after death of the father, that if I gave the license to the defendant independently.
It comes automatically, your lordship.
No.
If I would,
Since
if I would have
date of purchase, since the date of purchase, if you properly read the deed, that is exhibit 2, since the date of purchase,
yes, lordship.
there are, yes,
Other matter stands released for the day, man. It's 4 o'clock.
only 1554. Yes,
Half an hour is there, my lord.
yes, half an hour is big time.
My lord, I have asked my landlord to friend, my lord.
Now, okay, let me conclude this. Yes,
My lord, after the death of
no,
the
you just read the observation of first appellate court.
yes, lordship.
He said it was specifically pointed out that the preponderance of probabilities will carry on in this case. This is the only finding of the appellate court.
The settled principle is that a civil case principles of preponderance of evidence
Yes.
is applicable. No, what I am submitting before lordship, that what the defendants claim, as what your lordship has made out, that the present defendant, they are not the licensee. Their father was the licensee. Their father could have been a licensee, but after the death, the license goes. They cannot say their father could have been the licensee, but after the death of their father, they became the licensee because we have allowed them to be a licensee. And there is no specific avowment was made because it was not required to under law. It was not required to, because after the death of either of the licensor, because your lordship knows it, that as we make out in an agreement of tenancy, rather under the West Bengal Premises Tenancy Act or something like that, first, but it's after the death or something like that, the heirs, executors, and all these things have some right over the tenancy after the tenant or the landlord. But out here, there is no such thing like that. After the death of the licensor, either the licensor or the licensee, the entire license goes. So until or unless a fresh license was issued to the defendant, they wouldn't have been staying out there. And they're staying there because it was either expressly or impliedly. Impliedly, the license was extended to them.
No,
But-
you just go through the point of law, that is a substantial question of law,
Yes,
which
lordship.
was framed by the division bench of this court
Yes, Your Lordship.
regarding the judgment of the first appellate court. This is the only point here.
Whether the learned judge in the court below erred in law and fact in reversing the well-founded judgment passed by the learned trial judge, relying upon the evidence adduced by the parties. Now, Your Lordship will be relying upon the judge of the evidence of the parties then. We'll rely on that. Now, this law point has been made out on the basis of the alleged submissions being made by the parties in the evidence. What the my lord trial court has found while deciding the case. Lordship, it's at page 8.
You come to the issues.
6. Issues are not there. Nothing is there in issues. Issues, 3 issues are there. Is the suit maintainable in its present form? Is the plaintiff entitled to get a decree as prayed for? To what other reliefs is the plaintiff entitled? Lords, there's two scheduled properties. One is core and one is core. And declaration was sought for in respect of core scheduled property, that is 52 decimals of land, and recovery of possession in respect of core scheduled property, that's 8 decimals. And Lordship, the evidence it speaks of seven. And I'll place from page 6, Your Lordship. Plaintiff during his testimony has stated on the point of alleged license that the defendant was familiar to him and he was totally granted license in respect of 8 decimals of land for residential purposes in the month of Boishak, 1380 BS. But in para 4 of the plaint, it is stated that the defendant was his co-villagers and well acquainted with him, and he approached the plaintiff for the alleged license as he was in need of residential room, and plaintiff, being kind-hearted, granted oral license in respect of rooms of core scheduled property. But the noticeable thing is that the plaintiff, during testifying himself as PW1, never disclosed that he had intimacy or well acquaintancy with the defendant, that is, with Mrityunjay. Rather, he made contradictory statements during cross-examination to the effect that besides Bipin, father of the defendant, none approached before him for the alleged license. During cross-examination, he further disclosed that he had no relationship with Bipin and he did not grant license for the beneficial interest of the defendant. The more significant thing is that there is no whisper in the plaint as regards the particular date or dates on which the alleged license was granted to the defendant or defendant allegedly approached to him for the license. Plaintiff, during testifying himself, also failed to disclose the said particular date or dates. On the other hand, during cross-examination, he stated that the alleged license was granted on the date on which the defendant allegedly approached him. During cross-examination, he further disclosed that one Radhesham Ghosh was present along with the defendant at the time of grant of license. He further stated that the father of the defendant was not alive when Radhesham approached him for the said license. But during examination in chief, he stated that license was granted to Bipin, father of the defendant, on plot number 477. So all the aforesaid statements of PW1, which are contradictory to each other, cannot be relied on for believing the statement of the plaintiff to the effect of alleged license of the disputed property. The testimony of PW2, that is of Radhesham Das, also cannot be relied if his entire evidence on record is considered at a time. From the evidence of PW2, it transpires that alleged license was granted as per demand of the defendant, and at the time of granting license, he was called by the defendant to accompany him for approaching before the court, before the plaintiff, for the said license. So, Your Lordship, at least, as I submitted before Lordship, that someone accompanied,
No,
someone was there.
Forget about the evidence action. You just go to the finding of the learned
Finding, I will
trial
go, Your Lordship, but this is, as I submitted before Lordship, that someone was there. An independent witness was there when the license was granted.
court. Whether this
and
fact was
kindly, Your
considered
Lordship,
by the appellate
see,
court.
the trial court's finding, why the trial court disbelieved that the presence of PW2. He simply disbelieved that how could a person who doesn't have any interest, either before as a licensor or as a licensee or in the licensed premises, how he could accompany someone without having
No,
any interest over the property.
Yes, arguing otherwise.
Yes.
Whether this evidence of PW1 or PW2 was considered by the appellate court. This is the only question before the second appeal, not the otherwise. Only on point of law, this court has to be passed the order. Whether this statement of PW1 or PW2 is considered by the appellate court in disbelieving the well-founded order of the trial court. This is the finding. You read the finding at page 12. Trial court's finding. Second para, that is the below.
In this suit, although defendant could not establish the plea of adverse position, that one, Your Lordship?
Yes.
Yes. But it should be kept in mind that the plaintiff should not succeed on the lacuna of the defendant.
Yes.
Here, plaintiff could not establish the relationship of alleged licensee and licensor in between the parties.
Yes.
My Lord,
So this is the observation of learned trial court.
yes.
So what is the observation of first appellate court on basis of that?
My Lord, this finding was best after what I was submitting before Lordship.
Yes.
But this finding is contrary. This finding is contrary to what I am submitting before Lordship.
You are not supposed to, whether it is contrary or not. What is the finding of first appellate court?
First
On the
appellate court.
basis of that finding of the trial court. That has to be assessed in the second appeal, not like that. Whether it was correctly observed by the first
There is
appellate
no
court.
observation as such by first appellate court regarding the licensor and licensee relationship.
But the court is there. Your Lordship is there to decide. If the trial court has not taken into consideration the specific averments that is made by the parties out here in evidence, and so this finding is contrary to the evidence on record. This is contrary to the evidence on record that I could not prove the relationship of licensor and licensee, that is between the parties to the suit. When an independent evidence is there, he specifically stated and submitted that license was granted to the defendant. The finding on the basis of this submission means this evidence, Your Lordship, this piece of evidence, that's evidence of PW1 and PW2, at least of PW2, this finding is contrary. This finding is not correct.
No, PW2 has said that the father of that is the Bipin. Bipin was in possession. He has seen that.
But he expired. And this on the date, Your Lordship,
You read page 7, what from
could
you are
happen, Your
reading.
Lordship, but this Bipin was not alive
No.
at that point of time.
Yes, Bipin was alive, you see. You see page 7, PW2, what he said. That was you are reading.
The testimony of PW2
Yes.
of Radhesham Das also cannot be reliable in its entire evidence on record is considered at a time. From the evidence of PW2, it transpires that alleged license was granted as per demand of the defendant, And at the time of granting license, he was called by the defendant to accompany him for approaching before the plaintiff for the said license. During his own testimony, the said witness father discloses that Biffin used to possess as a licensee.
Yes.
Used to possess. But he's no more in this world. He expired.
Read us.
Yes, yes. And in cross-examination, he also disclosed that prayer for license from the plaintiff for residential purposes and from his cross-examination, it further reveals that he had no personal business with the plaintiff at the relevant time of granting license. Now the noticeable, that is it. The trial court disbelieved the evidence of PW2 only for the reason that he has no personal interest over the property. Why he would assist a particular person while the agreement was entered into. That is the fact that trial court has disbelieved PW2.
Not why the trial court disbelieved PW2, read thereafter.
That is it. Now that's what he stated. It further reveals that he had no personal business with the plaintiff at the relevant time of granting license. Now the noticeable thing is that there is no whisper in the plaint at the time of alleged granting of license. PW2 was present. Secondly, no evidence transpires from the testimonies of the parties that Radhesham had familiarity with the defendant. This is only two things, Your Lordship. The two reasons for which the plaintiff PW2's evidence was not taken into consideration.
This is the evidence.
One is, Your Lordship.
No, this is the evidence.
Yes.
On the basis of which the learned trial court has come to a finding.
Whether that is finding is correct or not.
So, no, that is not the issue to be decided here.
My lord,
Whether the first appellate court has decided the issue on what perspective, whether that is correct. This is the issue to be decided.
Yes, that is that. But Your Lordship, that will go.
Yes.
That will look into it. I will place it once again, Your Lordship, the issues being framed by the Honorable High Court on the point, page 45. Whether the learned judge in the court below erred in law and fact in reversing the well-founded judgment passed by the learned trial court. Yes, Lordship. So, Your Lordship.
So what is the observation of first appellate court?
Yes, that will go to it.
Yes.
My lord, let's start from page 21. My lord, I'll place from page 21, Your Lordship.
Yes.
That portion. The learned, that's on page 21, Your Lordship, third paragraph.
Yes.
The learned court below has also observed rightly, relying upon Exhibit B, RS Record of Right, showing possessions of BP in respect of 4 anni share in the suit property, that presumptions of possessions can be drawn, but by that entry, court cannot hold that BP was in adverse possession of the suit property. Rather, Exhibit B clearly shows permissive possessions of BP in respect of 4 anni share in cost schedule property. The defendant has relied upon Exhibit B, the RS record of rights in the name of Bipin Haldar, and the same has not been challenged by either side. The learned court below has also considered the reported decisions, nothing to do with it. Considering the above observations of the learned court below and relying upon the evidence adduced by the defendants regarding adverse possession, I find that the learned court below has rightly decided that the defendant has failed to prove his title by way of adverse possession. Also, I find that in this appeal, there is no cross appeal preferred by the defendant challenging the said decisions of the learned trial court below against him. Further, I find that the LR record of right exhibits that the entire cost schedule, that is nothing to do with it, the order of the proceedings preferred by the plaintiff appellant challenging the said recording, it appears that the petition was disallowed and held that the defendant was possessing the entire suit land for more than 35 years and the case was disposed of. In this regard, I find that the defendant is son of Bipin Haldar, who admittedly died in 1984. And as per Exhibit 3, RS record of right, Bipin Haldar was recorded as permissive possession in respect of 4 anni shares in the suit property, and father of the defendant being died in the year 84. This defendant cannot in any way possess the entire cost schedule property since 1365 BS for more than 35 years. Father settlement department cannot decide title of the property. Accordingly, by the said decisions of the proceedings, Exhibit C by 2, the learned settlement department cannot decide title of the defendant, or in other words, defendant cannot acquire title in the suit property in any manner. In spite of all these aspects, the learned court below has hesitated to declare the title of the plaintiff in cost schedule property. Rather, the learned court below has held that the observations that the plaintiff has not acquired title of the disputed plot by registered Kobala, though there is no denial.
You start reading page 23.
23. I'm placing 23 only.
Yes. In spite of all these aspects. Third paragraph.
Yes, Lordship. In spite of all these aspects, the learned court below has hesitated to declare the title of the plaintiff in the cost schedule property. Rather, the learned court below has held that the observations that the plaintiff has not acquired title of the disputed plot by registered Kobala, though there is no denial from the side of the defendant on the ground that there is no evidence that the disputed plot number 477 under Khatian number 148 by 1 is same and identical with one of 3 plots 461, 462 and 466, and also there being no demarcations in Ko and Ko. The settled principle is that admitted fact need not be proved. The suit property is the purchased property of the plaintiff. The dispute is that the defendant has acquired title by way of adverse possession since his father. In the same judgment, the learned court below has decided in the same breath that plaintiff has no title by purchase, and the defendant has, in the same judgment, the learned court below has decided in the same breath that plaintiff has no title by purchase, and the defendant has also not acquired title by way of adverse possession.
Yes.
This is completely wrong. Completely wrong in the sense, Your Lordship, the first portion we had stated that the trial court has specifically found that the plaintiff became owner in respect of the suit property by way of purchase. And the finding of the trial court in respect of the averment of the defendant with regard to their claim of adverse possession, that is there because they had not preferred any appeal challenging the said order. So that is binding on them. Now, in this case, there is no questions of demarcations of Ko and Ko schedule, and there is no question of in identifications of suit plot because there is no case of encroachment, and also from involvement of the plaintiff as well as RO.
Give me the LCR. Yes, you
Yes. It is clear that RS Khutian 148/1 is the LR Khutian number 1087, and from exhibit filed by the appellant before the appellate court, it appears that the suit plot number 477 was recorded in the name of Bipin Haldar with permissive possession in respect of 4 annas share of 60 decimals. And it is also not disputed that suit plot is not the plot mentioned in the impugned purchase deed, exhibit 2.
Yes.
Admittedly, the defendant respondent is in possession of in schedule property. The LR record of right shows that the defendant is in possessions in the entire suit property, but possession does not confer any title, and it has already been decided that defendant has not acquired any title in the suit property by way of adverse possession. Then how the possession of the defendant in schedule is legal right? In spite of all these, the learned court below has dismissed the prayer for eviction of defendant as licensed on the ground the plaintiff has not come before the court with clean hand. He has suppressed permissive possessions of Bipin, father of the defendant, in respect of 4 annas shares in schedule, and has failed to prove inductions of the defendant as licensee, where PW2, the corroborative evidence witness as to talk and inductions of the defendant as license was not uttered, has not uttered the name of the defendant in the cross-examination, who has deposed Bipin Haldar as licensee under the plaintiff.
Yes.
So it has been stated.
No, it has not stated. You go through the cross-examination. PW2 has stated that the Bipin is under license.
Was
Yes.
a license, because after the death of Bipin, he's
Nothing
present.
is there like that. You cannot make out a case like that.
Well, he died in the year 1984.
Whatever may be. That
But
is
that
the
is
case.
on
The
record, Your
plaintiff has
Lordship.
to come with the clean hand. This is the case.
But plaintiff did not suppress anything.
Yes, plaintiff suppressed. This is the finding of learned first appellate court. Plaintiff has not come with clean hand.
My lord,
Because
this is
they has to be said that the Bipin
my
was
lord,
in
my lord,
possession.
one more thing, Your Lordship. Let me. In spite of all these, the learned court below has dismissed the prayer for evictions of the defendant as licensee on the ground that the plaintiff has not come before the court with clean hand. It's not the finding of the first appellate court. It's the finding of the trial court. It's the first
Yes,
appellate court,
this is the observation of the trial court.
trial court. But the trial court, this observation is not correct.
You just read what he
Yes, Your Lordship, that's what I'm tracing. But this observation that is made is not by the trial court, first appellate court. This observation was of the trial court. Yes, Your Lordship. He has suppressed permissive possessions of Bipin, father of the defendant, in respect of 4 annas share in cost schedule, and has failed to prove inductions of defendant as licensee, because that is the fact that has been stated by the plaintiff in his plaintiff's case. My lord, in the plaintiff's case, he could have stated that prior to the inductions or granting the license or renewing the license in favor of the defendant, his father was granted license, or his father was in possession of the part of the suit property as a licensee. But after his death, the sons, the plaintiff has allowed the defendant to be in the property as a licensee. That is, my lord,
plaintiff should be clear, clean to that effect.
that is optional, Your Lordship. My
No,
lord,
not
for
optional.
that, Your Lordship, for not stating the name, for not uttering the name of the fathers of the defendant.
Not optional. When you are claiming title over a deed, from a deed, so you have to state that from the after purchase who were in possession. Why you suppress the fact that the father of the defendant was in possession? You are claiming title from the deed.
Yes,
So after purchasing, record shows the father of the that is the Bipin.
as a licensee, they have no right.
Whatever may be the license.
Yes.
License is the issue here. Why you suppressed?
My lord, how
No,
the
the
plaintiff-
suppression as considered by the learned trial
that
court
will be relying
was
upon,
also
my lord, will be
considered,
placing
was also
definitely.
considered by the learned first appellate court. You just apprise this me that whether the observation of the first appellate court is correct on the basis of that. You
My
just
lord,
read it.
Yes, I'm placing it, Your Lordship. So the finding that this portion, Your Lordship, that the plaintiff has allegedly made suppressions. This is not the finding of the first appellate court,
I
but this,
understand.
yes, Your Lordship. Let me place it because the further portions. The father of the defendant in respect of 4 annas of shares in cause schedule and has failed to prove inductions of the defendant as licensee, where PW2 corroborative evidence,
Forward to witness.
witness as to talk and inductions of defendant as licensee has not uttered the name of the defendant in his cross-examination, who has deposed Bipin Haldar as licensee under the plaintiff. The settled principle is that the civil cases principles of preponderance of probabilities is applicable. So, my lord, out here, the thing is there. What the learned trial court has specifically stated that the finding of the trial court, and subsequently it has been stated, Your Lordship, that suppression was made, alleged suppression was made with regard to granting of permissive possessions to Bipin, father of the defendant. In respect of 4 anna shares in cause schedule and has failed to prove inductions of the defendant as licensee. So the first portion, Your Lordship, that is there. What I humbly submitted, that since the defendant father was no more in the world, he expired long prior to this.
You cannot make out such a case like that. Here, what is the finding of learned trial court? What is the finding of the appellate court? That has to be considered.
Yes.
Only.
Yes.
Not beyond that or the no new.
No, we are not going to go beyond that.
Yes.
We are not going to go beyond that. But the appeal court subsequently says that while the granting of license to the defendant by the plaintiff, the same has been proved with an independent witness, that is PW2.
No, PW2, you cannot rely upon the PW2. PW2 is not at all reliable. He stated something in the chief and cross-examination
My lord,
forget everything.
that Your Lordship, everyone has stated
No,
contrary,
no.
statements.
Evidence means
Entire-
the examination chief and examination cross-examination jointly, not the otherwise.
But what sort of contrary statements that has been made by PW?
We are not going
It's
to
only-
that evidence like that.
My lord,
Now
only
we
thing
are
is that
here.
it is stated that the plaintiff's defendant's father was granted license, and subsequently this is the defendant was granted license. It could have been the plaintiff's father would have been
cannot
granted
understand
license,
what
but
is
after the
finding
date
of
his
the appellate court on the basis of that.
the appellate court specifically speaks of this.
Yes.
Kindly, Your
What the
Lordship.
appellate court said
Yes, Your
on the
Lordship.
basis of that.
Yes.
That has to be looked into whether
Yes,
it is
Your
correct
Lordship.
or not.
The defend as licensee where PW2 corroborative witness as to talk and inductions of the defendant as licensee has not uttered the name of the defendant
Yes.
in his cross-examination, who has deposed Bipin Haldar as licensed under the plaintiff. The settled principle is that in civil cases, principles of preponderance of probabilities is applicable. So, Your Lordship, the first appellate court, this piece of finding that with regard to the finding of the trial court and with regard to the depositions made by PW2, wherein it has been stated that PW2 once named the father of the defendant as the licensee, and in other places he has deposed that the defendant was inducted as a licensee. This is it, Your Lordship. Now, regarding burden of proof in the matter of license, the learned lawyer of this relating to proof by preponderance of probabilities had relied upon a judgment that is reported on this. In this case, it is clear in evidence that Bipin Haldar, father of the defendant, was licensee in respect of 15 decimals of land, and he died on 15/4/1984. Though this is not the pleading in the plaint. The plaint case is defendant was licensee under the plaintiff in respect of 8 decimals of land only. Because this finding is definitely correct, Your Lordship. What I would humbly submit, because after the death of the father of the defendant, he is no more in the picture. 7, except his name is existing in the.
How can it be 8 decimal? How can it be 8 decimal?
It could have been renewed. The defendant could have agreed to that. His father, it could have been the father was granted 15 decimals of.
Fact shows otherwise. The father of the defendant was over 15 decimal of land,
Yes,
as record shows.
yes,
Plaintiff says the defendant is in possession under license of 8 decimal of land,
yes,
but the record shows,
yes,
subsequent record and
Yes.
proceeding shows,
yes.
the defendant is possessing entire suit property.
That is in the ELA record.
I understand
That is the
but
that is the ELA record. So, Your Lordship, kindly look
possession
to.
is clear.
Yes,
Title, I forget about the title. The
But
possession
kindly-
is clear.
kindly look into it. Kindly consider a person who claims whose name is recorded in the RS record in respect of 4 anacia, that is 15 decimals of land, and his name subsequently his children's name of his children's are appearing in the ELA record in respect of entirety of the land. How could that be?
Yes, it was proved.
That is
They are in possession of entire land. It is proved by the recording of the proceeding.
But how could that be, Your Lordship? But that
No,
it doesn't.
that is not
it
the
doesn't-
title, but the possession is perfect. They are possessing entire property. This is perfect. You have not preferred any appeal before any other authority against the order of the concerned DL and LRO.
Yes, they have preferred an appeal. The writ petition was filed and that was dismissed.
Appeal is that was dismissed.
Dismissed.
So for
They have
that
never
query-
filed any appeal against
That
the.
query is concerned at the time of argument, Malan defendant argued.
Yes.
Your Lordship would decline to hear with regard to this aspect is concerned because this matter sitting with regard to the issue framed by the High Court in respect.
Yes, that is altogether other
And-
issue as it is
I
decided.
need not to be
And
troubled because
yes,
so for the
so only whether the finding of learned trial court, learned well founded, this is the point of law. Substantial question of law, it has to be decided here.
Yes.
Whether the well-founded judgment of learned trial court was correctly disbelieved
Now-
by the first
Now,
appellate
Your
court.
Lordship, to see also that whether the trial court's finding was well founded on the basis of
No,
the.
no, that is not
Your
the
Lordship, to see that because
No,
Your Lordship
no,
finally deciding the appeal.
I have to decide on the basis of point of law.
Yes.
Substantial
That
question
is,
of
that
law.
is,
which
my
are
lord,
involved.
that is also a point of law, my lord. With the second appeal,
Substantial question of law, nothing
Yes.
of merit or the evidence or
my
the.
lord,
Moreover, my lord, what is the suit is all about? The suit is not an ejectment suit.
Okay, no, just wait. You just check. Yes, proceed. Whether this finding is correct to set aside the well-founded judgment of the trial court. This is the only question here.
my
Not
lord,
on other fact. You understand?
yes, Lordship.
Only very simple and short question. Whether the finding of learned trial court, when it was set aside by the first appellate court, whether it is justified.
But Your Lordship, I humbly, once again, my lord, repeating Your Lordship, that Your Lordship to find this also, whether the trial court findings is at all correct or not.
No.
Your Lordship
That
to
is-
see that
no,
also,
no,
because in
no.
Your Lordship,
Substantial question
my
of
lord,
law
the
means
substantial, my lord, that is at the initial stage. That honorable court has made certain findings, but you are to Your Lordship to decide it finally. Your Lordship to decide finally after taking into consideration everything of the matter, because Your Lordship knows when a matter, the second appeal matter, at the time of admission, how an appeal is admitted.
okay, that's all.
Yes, Lordship. I will come on the next day. I will complete my argument. I'll be relying on certain documents, whatever it is, because it is on record. In one hand, he says that I am the owner, admittedly, and subsequently he's denying my right. How could
Admittedly,
that
there are some lacuna in the pleadings and the proof and the evidence of the plaintiff. Admittedly, there are some evidence, glaring evidences are there. When you claiming title on the dint of a deed of sale, thereafter you just forget about, say, the possession of record of right, that the father of the BP was in possession. You just omit and saying that the defendant is in possession, and your witness PW2 is not supporting. PW2 is not supporting. You read PW2. You will utter surprise.
I'll come up. I'll look at it.
Yes,
I mean,
I have already gone through entire record.
yes, Your Lordship.
I can give you only one chance to argue.
Yes, Your Lordship. I'll conclude it. On the next time,
Conclude it.
I'll conclude.
My lord, let the interim order be extended because it was till today.
25. What a reply, Choro. এটা 18 তারিখে কি আছে? 18 তারিখ। Two PM তো? 2 PM নেই। 2 PM আছে? Okay, 18th. 18th at 2 PM.
But one line to be added, my lord, that interim order to be extended. The can is made, it is
Okay,
pending.
please take down.
Still pending.
Argument on behalf of the respondent heard in part. Let the matter appear in the list on 18th of June 2025 at 2 PM as a specially fixed matter. Full stop. Next, interim order passed by this court on the earlier occasion is further extended till the adjourned date. You conclude on that.
Yes, Your Lordship. I'll do it.
I have read entire evidence, entire record, entire everything.
Yes.
Okay, thank you.
Right, Your Lordship.